issues for consideration before we address the matter of the witness statement. My first concern is whether we have a judicial officer where the witness will be testifying from, so that we are certain that there's nobody or no means of prompting him when questions are asked. Because this is very important in our view.
We discussed in detail the modalities for this evidence and the concerns which were raised by counsel on the other side. And you all took it into consideration. So, Mr. Akoto Ampaw, let's move on and do some business.
Since that discussion, in fact, that very day, they wrote waiving those confidential matters.
Yes.
And therefore, we are saying that this is a trial. Normally, even when somebody is giving evidence from abroad, you have an officer present whilst he's giving evidence. I think this is a very fundamental issue I'm raising.
Mr. Akoto Ampaw, why didn't you come with the other counsel into chambers to tell us this morning?
My lords, because we were told that this matter will be discussed, the case is now to be in public. That is why. Otherwise, I would have done that. But I submit that this is a very major concern for the second respondent. We want to be sure that the witness is not being prompted or given any assistance. And that can only be properly done if there is some oversight by an official of the court.
What's your next concern? You said you had a number.
Yes, my lord. My next concern is your lordships will notice from the witness statement and the attached statement of truth that the attached statement of truth reads, I, Robert Joseph Metonunu, say that I am the witness herein, and that I made this statement in respect of this presidential election petition, and that to the best of my knowledge and honest belief, paragraphs 1 to 16 of the witness statement are true to the best of my knowledge, information, and belief. Now, that means that the witness has only sworn to paragraphs 1 to 16 of the witness statement.
Mr. Akoto Ampaw, what are the legal arguments around this?
No, my lord, I'm coming to the point.
No, Mr. Akoto Ampaw, I thought you said you had some preliminary matters.
Yes.
No, wait. Now, I think this you raise when an attempt is made to put the statement into the proceedings. So we'll take the preliminary ones. This relates to the statement itself.
Very well. Available to your lordship's guidance.
With the first preliminary issue that you raised, I think we can observe his demeanor. I mean, you can observe his demeanor if somebody is talking to him or passing a document to him. We can observe from the screen. So I don't think.
My Lord, can I be of assistance to the court? My Lord, may I be of assistance to the court? My Lord, we are completely in agreement with the principle that a judicial officer can be in attendance. We have absolutely no problem about that. And my lords...
Peter, can you speak into the microphone?
I'm sorry.
Otherwise, we lose the record.
In terms of that principle, it's very clear we are not in objection. So it should take perhaps not more than 25 minutes to have a judicial officer present at the location where he is to allay the fears. So respectfully, my lords, if a judicial officer can be designated, that judicial officer can go to the venue, which, you know, I mean, that should not be a problem.
Would it be safe? How proximate can this judicial officer get?
Oh,
In view of what you have told us.
my lord, in fact, I'm certain there's actually a medical officer also in attendance at the location. So I'm sure that he can have a discussion with our medical officer in terms of the issues that your lordship is addressing. I'm pretty certain about that. The medical officer has provided a letter also to the court, and I believe that he can address that issue. Currently, according to the review from the day that your lordship's granted us indulgence, that issue really does not arise currently. But the judicial officer probably can actually be in the room, because I think, as far as I recall about the judicial officer can just go there, and in conjunction with both the medical officer and
please, we will adjourn for 30 minutes and consider this. No, you will send somebody. Yes. Okay. Yes, we will arrange with you through the registrar. Yeah, okay.
Particular issue. Reporting for Joy News from the Supreme Court, my name is Joseph Akable. Mainly on the request to have some documents inspected. These are documents that are in the custody of the Electoral Commission. Our lawyers on the various sides, starting from Mr. Mahame's legal team, advanced arguments in support of their request to inspect those documents. They insisted that in the course of the trial, it has been established that there are instances of different pink sheets for the same areas, and so they wanted to inspect the original documents. But lawyers for the Electoral Commission and President Akufo-Addo did indicate that as far as they are concerned, these are documents that are in the custody of the petitioner, and so the court should not grant the request. The court listened to the legal arguments and ruled that a case for the grant of the request has not been made. So here is a wrap of the legal arguments in support of the request and the decision of the court as well.
Because we are saying effectively that this access to these documents is required for a fair hearing in this case, because it is not within the province of the first respondent just to pick and choose numbers from different sheets in the way they sought to do in cross-examining on Exhibit D. It's not within their province just to pick and choose and say, oh, this document which you have, it didn't include Ayenswanu. There's nothing on the face of the document which says Ayenswanu is there or not there. Nothing.
I do not believe that it has been the practice of our courts that evidence is led in piecemeal. Evidence cannot be led in piecemeal before the High Court, how much more the Supreme Court. So, my lords, it is our submission that for these grounds, and of course, they bear the burden of proof to provide evidence sufficiently for the burden to shift. They have it, and having failed to do that, they cannot, at this late hour, come and make this application for documents which the witnesses themselves admit are in their possession. That is our submission, my lords.
I'm saying, my lords, with all due respect, that the applications seeks to use